I'm Dave Megay, and I'm joined by my partner Jim Kovaleski. Jim, thanks for joining me tonight.
Absolutely.
Or
Thanks.
maybe you should thank me for joining you tonight. Anyway, Jim, let's further tonight's little piece. Let's talk about agreements of sale, residential and/or commercial. Well, let's focus on residential agreements of sale.
Okay.
Although, folks, the concepts we're going to touch on apply to both, and this is whether you're buying the property, Jim, through a realtor, and we love realtors. They're our major source of business for us. We work with them every day, or whether you're buying it privately.
Yes.
Folks, when an agreement of sale comes across your desk or across your inbox from your realtor, it doesn't matter whether you're selling or buying, there's a couple of 5 to 6 points. Jim, what's the first one you look for as attorney for, let's say you're the buyer, attorney for the buyer, or you represent the buyer?
To be honest with you, whether I'm representing the buyer or seller, the first thing I look at is what's the purchase price and what are the deposit terms, because that's where the deal begins and ends with, right? It's what the parties have agreed that the property is worth, and it's the security that the seller is getting from the buyer in the form of the security deposit. So I want to see what's the number there, how much is it, how much is the purchase price, how much is the deposit, when is the deposit due, and what potentially could cause, if I'm representing the buyer, like we started the conversation, how can my client potentially lose that deposit? Meaning, if the sale doesn't go to closing, most do, some don't. So if this is one of the ones that it doesn't get it to closing, how can my buyer potentially lose the money that they've put down as a security deposit? Because that's going to be very important to me, but more importantly, very important to my client.
Right, and as whether you're the seller or the buyer, the amount of the deposit is affected by, well, number one, negotiations, whatever you can negotiate. The higher the amount from a seller standpoint, the better, right?
Absolutely.
The lower amount from the buyer standpoint, the better. But also, Jim, the deposit amount is also dictated by when closing is. How far is closing from the agreement of sale? So, folks, whether you're buyer or the seller, let's say you're the seller and you sign an agreement of sale today and settlement it's in 3 weeks, you as the seller can be satisfied with a lower amount than if the settlement was 3 months from now.
Absolutely.
Because that deposit takes the property off the market for that time period.
Absolutely, and to take it one step further, I know we're not talking about commercial agreements, but in a commercial agreement where the property can be tied up for 18 months while you get approvals, you might be talking about tens, if not hundreds of thousands of dollars in the form of a deposit, because you're locking that property up for that period of time.
Right, right. One more thing on the deposit. Jim, I've heard a phrase through my career, liquidated damages. And let our viewers know briefly what that is and how it relates to the deposit.
Sure. Particularly if you're using the PAR form, which is the standard form that we see for residential transactions. Buried somewhere, I think it's on page 10 or 11, you'll see this little check the box, and it says the seller's limited to retaining the deposit as liquidated damages. So what does that mean when you check that box? Basically, what it means is this. If there is a default by the buyer, meaning that the buyer has decided not to go to closing, and there's no contingencies left, which we'll talk about contingencies here in a moment, to protect the buyer, then the buyer's at risk, he's in default or she's in default. If that box is checked, the seller gets to keep the deposit. That's their liquidated damages, meaning that's the amount that the buyer and seller have agreed the seller has been damaged, and then they go their separate ways. So what it does is it protects the buyer a little bit, and it gives the seller knowledge as to if there is a default, the seller's going to get to keep that, the buyer's going to lose it, but that's the set amount. So both parties know that's going to be the cap on damages.
And in effect, it also protects the buyer, doesn't it? Because that way the buyer knows if the buyer gets through the agreement of sale and there are no more contingencies to protect the buyer, and the buyer wants to walk, buyer gets cold feet, or what's that phrase, buyer's remorse, the buyer can or knows that if the buyer walks away from the deal, the most the buyer can lose is the amount of the deposit.
Absolutely.
Well, Jim, let's talk, because we're running short of time, let's talk next on an agreement of sale, what our viewers should be looking for. I'm going to gild the lily here a little bit and say the next is the settlement date.
Settlement date. You touched on it. It's important to both the seller and the buyer to know what that settlement date is. Oftentimes they want it out, depending if the buyer has to sell their home that they're currently in. The seller may have time constraints that they need to get out. So it's really important to come to an agreement and to understand what that settlement date is, because that's the day all the parties are obligated to sit around a table just like this and to go through closing. So making sure you understand what that date is and making sure you get to that date as buyer or seller is very important.
Well, while you're talking about dates, Jimmy, you mentioned the term contingencies, such as a mortgage contingency or a home inspection contingency, due diligence contingency if it's a commercial matter. Those contingencies protect the buyer.
Yes.
Right? And it gives the buyer an opportunity to get out of the deal and get their deposit back that Jim and I talk so much about, so long as the buyer, or if the buyer's not satisfied with the contingency, like the home inspection results, can't get a mortgage, etc. But the dates of those contingencies are very, very important. That's, I'll speak for you. When we meet with clients, sellers or buyers, you've seen me do it a million times over all these years, and I've seen you do the same. Right away, we're doing a chronology of the dates so that everyone is on the same page. None of this, well, it's 15 days from, 15 business days from now, or 10 business days from now. No, we're going to nail down the dates. You have X date to get your mortgage. You have Y date to get the home inspection. You have Z date to review the financials associated with the property if it's a commercial. Those dates are very important, and there's a phrase, I'm going to test you, there's a phrase in the agreement that documents how important those dates are, and the phrase is?
Time is of the essence, Dave.
Right, which is very good. That just means that, folks, those dates are serious dates. It's not just April 2nd, well, ish. There's no ish with time is of the essence.
No, it's your intent. By including that in the agreement, it's your intent, and it shows your intent to say that that date means something. I've agreed that I'm going to do whatever I need to do by that date, or terminate the deal if that's the way it ends up, but I'm going to do it by that date, and that's it. And if I go beyond it, that's on me. That's my fault.
Okay. Now, Jim, we have a minute or two left here. Whether we're the buyer or the seller of a residential property, we're always looking for the seller to complete a document even before the agreement of sale is signed. And what's that document called?
Absolutely. So in residential, when you're dealing with residential properties, with very few exceptions, a document called a seller's disclosure needs to be completed and completed by the seller and given by the seller to the buyer so that they can review it. And what the purpose of that seller's disclosure is, and sellers don't like to hear this when I'm talking about them, but it's your obligation to disclose any warts, any issues, any problems that you've experienced with your home while you've owned it. It's a very long, very broad form that goes over all different kinds of things, from your roof down to your foundation, from the exterior siding or whatever's on the outside, the plumbing, every major system. They want you to disclose, they want you as the seller to disclose whatever you know about those to the buyer. I always tell my clients, be very full in your disclosure, because that can only protect you. The buyer can't come back and say, well, you never told me this, if on the seller's disclosure you told them about an issue.
Right, it protects. So there really isn't necessarily anything known as is. I mean, you could say as is, but all that means is, seller, you need to tell me about everything, but I understand you're not going to be fixing anything.
Yep.
So folks, you've been watching, we're up against it now, we're done. We really appreciate you tuning in to Legal Talk, brought to you by O'Donnell, Weiss and Megay Law Offices. I'm Dave Megay, joined by Jim Kovaleski tonight. Your life, your business, your law firm.
Thank you.